Provided, however, that notwithstanding subsection G of Code Section 511233, that deals with the issue of the requirements of seatbelt, while the trier of fact may reduce a person's right of recovery. That deals with the contributory negligence. While the trier of fact may reduce a person's right to recover damages according to the proportional of damages attributable to the person's failure to wear a seatbelt, a person's failure to wear a seatbelt shall not serve to deprive such person from recovering that portion of his damages attributable to the negligence of another. So we have tried to be very careful in wording this as a means of saying you can have a reduction, but you would not have potential loss of whatever other damages that may be the result of some other party's negligence to you. Mr. Speaker, with that convoluted explanation, I'll be glad to take some questions.
I'm still working on the MARTA bill. Do you got no? Oh no, you've got more questions than that bill had. You want to start? Yeah, I thought so. You might have just made that simple enough to complicate it. Representative Hatfield has a question.
Okay. Thank you, Mr. Speaker. Will the gentleman yield?
I'll yield.
Mr. Chairman, isn't it true that this bill would allow, in a situation where a party was not at fault in an automobile wreck and was a claimant in a case like that based on an automobile wreck that was not their fault, would allow an insurance company to use the failure to wear seat belts as a means of being able to deprive that party of a recovery?
There's a factual issue. If there's injuries that resulted from the failure to use a seat belt, that could cause a reduction of his or her ability to recover. And so part of what we're looking at here is the encouraging of conduct. That's part of what tort law and tortfeasor law does, is to encourage appropriate good conduct.
Will the gentleman further yield?
One more.
Isn't it true, Mr. Chairman, that this bill will require will increase the costs of litigation by requiring the parties to hire experts to litigate the question of whether or not a party was wearing a seatbelt and whether or not that contributed to their injuries?
The only requirement you'd have is someone who would be a medical expert, potentially. The defense may hire to show that the injuries that they received for failure to wear a seatbelt were, in part or whole, a result of the failure to have the seatbelt on. I think that's all we have for you. Any other questions, Mr. Speaker? That's all.
A lot of other questions.
I got other people. I've got other people. I've already.
Hang on just a minute. Hang on. Now, I'm going to tell y'all, I'm going to get some order. Representative Willard, with all due respect to you, this process works by a set of rules.
Yes, sir.
And he's recognized it.
Mr. Speaker, just one final
I understand.
question.
He gets to ask questions as long as you wish to yield for questions. Okay. You can either yield the well or I'll cut him off. But right now, I'm going to let him ask one more question.
Okay. Thank you, Mr. Speaker. Mr. Chairman, isn't it true that this bill would benefit insurance companies who have the money and the means to be able to put experts on permanent retainer to serve as experts in every automobile case to argue that failure to wear seat belts comes into play?
I don't believe that.
Thank you.
Representative Smith has a question to your right.
To my friend in the well.
Yes, sir.
Will you yield for question?
I do.
At what point do you realize that someone was not wearing a seatbelt when in fact in the heat of the moment they took their seatbelt off because maybe they were strangling? Is that not true?
Because they were what? I couldn't hear you.
Because they were possibly strangling.
Strangling?
Is that not true?
Well, you can tell pretty much by the type of injuries a person has whether or not they had the seatbelt on at the time of the collision.
Will you yield further?
Yes, sir.
Do you have 100% proof that you can, in fact, find that someone did not have the seatbelts on?
If someone is saying they did not have their seatbelt on or did have the seatbelt on, at the time of collision, that could become a factual issue for the jury to determine. Yes, sir.
Will you yield further?
Yes, sir.
Is there any time that you could determine in a court of law that 100% somebody had their seatbelt on.
I'm really having trouble hearing you because you got the mic a little too close.
I'm trying to determine, sir, is that there any way that you can prove 100% that someone had a seatbelt on or did not have a seatbelt on?
Well, you'll have, say, part of the injuries, I think, would also show whether or not a seatbelt was on at the time of the collision. If there's a disputed fact on whether there was or was not one on, the person who says, I did have it on, and there may be evidence saying they didn't have it on, that becomes a factual issue for the jury to decide. So there's no other way other than to say the trier of fact makes that decision.
Will you get further?
Yes, sir.
I'm trying to still ascertain, sir, how a court of law can 100% be certain that somebody had a seatbelt on at the time of the accident, when in fact they could have been scraped or burned some other way, getting out of the car or the vehicle. Is it not true to prove that there's 100%?
I don't suggest or be able to answer your question with saying there's absolutely 100% certainty in every situation, Ms. Smith.
One further question.
Okay.
So, sir, is it not true that the medical examiners could prove 100% that a seatbelt was worn or not?
The medical examiner in a death case you're talking about, usually the type of injuries a person has can show whether or not there was a seatbelt on the person at the time of the collision. Yes, sir.
Representative Morris has a question to your right as well. That little group right over here.
I'm sorry.
Thank you, Mr. Speaker. Mr. Chairman, do you
Yes,
yield?
I do.
Let me ask you a hypothetical question. Let's say that I'm involved in an accident with an uninsured motorist, and there's some dispute as to whether or not I was wearing my seat belt. Can my personal insurance company deny my claim
A little closer.
in this instance?
Philip, a little closer. I'm having trouble hearing you.
Okay.
Just let me get some order. There's House will come to order. I know it's late in the day. We're debating an important bill. House will come to order. All members. All members. Gentlemen, continue.
Thank you, Mr. Speaker. Mr. Chairman, the question I had was a hypothetical question.
Yes,
if
sir.
I'm involved in an accident with an uninsured motorist and I have zero liability, if there's some dispute as to whether or not I was wearing my seat belt, can my own insurance company use that evidence to deny my claim?
You're in effect have uninsured motorist coverage, and unfortunately what happens with any type of accident, your uninsured motorist coverage becomes in effect a coverage on that uninsured person which you're seeking to recover. And so in effect, yes, if that's the issue about whether you had your seatbelt on or not with the injuries you sustained, they could use that in saying as a part of your uninsured motorist coverage. Remember, that becomes what you bought as insurance to put on that person who was uninsured. Correct.
Thank you.
Representative Sims has a question.
Mr. Chairman, I'm over here to your left.
To your left.
Pardon.
Mr. Chairman, if this is another hypothetical question, if I'm parked in either parallel parked or in a parking lot, and some blind Tom comes along and piles into the rear end of me, and I don't have my seat belt on, that's going to mean that this bill would keep me from having any of my health taken care of at that point in time?
Good question, Representative Sims. The answer is no, because the requirement of a seat belt is in the operation of the vehicle on a road, moving.
Representative O'Neill has a question in the center aisle.
Will the gentleman yield?
Yes, sir.
I'm confused between, I guess, the concepts of negligence as it is recited in the bill and the concept of injury. Isn't it true that in a trial of an accident case, the first determination is of negligence of one party or the other?
Correct.
And thereafter, then damages are sought to be proven by the aggrieved party against which is found.
Good question.
In this language, it says that recovering that portion of his or her damages attributable to the negligence